An important part of the resource management planning system is, so what we're going to talk about is standing, who has standing to bring an appeal and what standing is, the preliminary conference, which is the first steps in the appeals process, what are some methods of alternative dispute resolution, so what can you do other than go to a hearing and hand over the power to an independent arbitrator, a bit more detail about mediation in particular and how mediation works because it's a very important tool for the tribunal, and then finally hearings. So standing is a funny word. I always imagine the common use of standing when I hear this, but it's a legal term for those people who have power to appeal. So Section 61 of the Land Use Planning Appeals Act talks about standing in some detail and lays out in legal terms that basically you're talking about two groups of people. You're talking about the applicant for the permit application, which is sometimes the owner of the site, but not always, and people who put in representations during the development application public comment period. So there's a range of scenarios under which these people can lodge an appeal. The relevant section of Jared's manual is really good in laying out in detail and then in summary who has standing. So standing is basically the applicant for a permit who's unhappy with the permit or the permit conditions, people who've made a representation, so they have right of appeal if they're not happy. If the applicant for a permit is refused a permit, then there are some grounds on which they can appeal that decision. People who, or a relevant agency who's made a representation to a discretionary application, and under Part 5 of LUPA, Part 5 agreements are mostly used when it comes to biodiversity conservation. That's one of the common things, but they're also used in a broader sense. If the owner of a property as part of permit conditions is required to enter a Part 5 agreement, they might want to appeal that. And then persons who under LUPA are subject to enforcement have an appeal right. So this is broadly about natural justice and making sure that any conditions that are imposed either on neighbours or on the owner of a property, that the person who's unhappy about the outcome is able to go to an independent body, the tribunal, and say, not happy. There's a lot of detail in Jared's manual about timeframes. The important thing here is that the time starts the day after the email is sent or the day after the date on the letter, and that's usually 14 days for most situations. So this is important because people get cranky when they find out that their letter's taken, several days to be delivered, but actually the time's been ticking that whole period. So this is just something to be aware of, and it's in LUPA, so there's nothing that an individual can do about that. The preliminary conference is the next important part of the appeals process. So if you've approached the tribunal and you've brought a matter, then this is the first meeting, and this text is out of Jared's manual, of all the parties who are directly involved in the dispute. So the tribunal is guided by the Resource Management Planning Appeals Tribunal Act, and that makes it clear who has standing, who has automatic standing, and who can apply to join the appeal. The tribunal advertises the existence of the appeal, so under natural justice, people are afforded the opportunity to have their say if they think that they might be affected by a proposal. And so you'll see this kind of notice in the relevant local newspaper stuff. If it's a Launceston issue, it'll appear in the Examiner, Northwest the Advocate, South the Mercury. The preliminary conference establishes the parties and deals with any applications to join. So for example, in the Pages Road case, there was one of the neighbours who put the appeal, but then two other neighbours joined in and were part of that appellant team. The preliminary conference crystallises the issues. So what is at the core of the problem, and really tries to wade through and make sure that there aren't matters of law which can't be dealt with through negotiation through the tribunal, and also that the parties are clear about what is in dispute and there isn't a fundamental misunderstanding about it being the east elevation window when actually somebody's concerned about something else. And yeah, just making sure that that's really clear. The directions for the full hearing are set, and then any evidence is exchanged. So again, natural justice means that people need access to all of the documentation that's being made to to each people's case, and then that they have an opportunity to cross-examine and interrogate that eventually down the track. And the alternative dispute resolution is explored. Obviously, there are situations in which you wouldn't put people into mediation, particularly if there's, been threats, harm, particularly bitter history between the parties, then it's probably not a realistic alternative, but that's explored as part of the preliminary conference. The unit manual goes into each of these particular issues, these particular parts of the preliminary conference in quite a bit of depth. So this is the part about evidence. I haven't put the whole bit in, but just to say that going back to the unit manual is good here just to flesh this out. In terms of alternative dispute resolution, then these are the kind of options from the very minimal guidance end where the parties are facilitated right through to the full hearing, where basically all the power is given over to the independent arbitrator, to the set of commissioners, the commissioner. So, and then you've got all these different people, different methods in between. So just briefly to talk about each of these, the facilitator offers minimal guidance and a very low level of intervention in terms of resolving the dispute. So they're really not providing a lot of structure. They're certainly not providing any opinions or unsolicited guidance. They're there to get the parties together and help them through in a very minimal way. A mediator, which I'll talk more about in a couple of slides, is a more structured intervention that helps the parties clarify what are the issues and work through it in a very systematic way, and tries to not so much take the emotion out of it, but work through it really logically so that you don't get swept up by feelings of being hard done by and being powerless, that you work through it carefully. The conciliator, and people need expert training in conciliation to work in this role. A conciliator is a step up from mediation in that they might express opinions. They're allowed to express opinions in the matter to flag areas of knowledge that might assist in making decisions. So a conciliator is allowed to say to parties, do you realise that if you take this to a full hearing and it doesn't go your way, you might end up not only having to pay your costs, but having to pay the other party's costs as well. Are you aware of this as a possible outcome of the process that you're on? So the conciliator might help nudge, inform the parties in such a way that they reach a resolution faster, or they reach a better resolution. Further down the line, the neutral expert evaluator will actually give an opinion on the likely outcome. So where the conciliator won't say, look, you are going to lose, so don't go to a hearing, the neutral expert evaluator is somebody who has the necessary background to deal with that particular issue and will actually give an opinion on the likely outcome of going to a hearing. So they can say, look, based on what I've heard, you're likely to lose, the other person's likely to win, whatever the situation is. And they can come up with ideas that are independent of anything that the parties have put forward because they're the expert in that particular area. So it's not a formal hearing, but it's heading down that track where an independent expert can say, based on what I've heard, this is what I think is going to happen. And then there's the actual formal hearing. Alternative dispute resolution is a really important tool of the tribunals because a very high proportion of all of the cases that come before it are actually settled through mediation and conciliation. The preliminary conference is important because this is the place where we see whether perhaps the dispute is about a question of law, so not something that could be subject to mediation. And the mediator might realise that there could be possible threats to the safety of party, possible coercion, such that somebody who's in mediation is going to be somehow, not able to kind of freely express their opinion for whatever reason, for financial influence or some other personal tie, then the mediator might decide that the matter isn't appropriate for mediation and just set it down as a hearing. And I do know of examples where people have gone to the tribunal and relationships are just beyond repair. By the time they get to the tribunal, neighbours who've had an ongoing history of dispute, and it's really clear it's not going to work. But this is important. Mediation happens this way. If the matter does appear before a commissioner or a full bench of commissioners, then there's a process around this. And this is something that we're going to work through as a class. There is a lot of information on the tribunal website. I'm not going to go through it here. There's also quite a bit of detail in the manual. So this is an excerpt out of the manual, stepping you through, okay, the panel is a bunch of experts. There's a whole range of people that an individual appeal can draw on. They need to be appropriate. So there's all of this detail, this background. If you need more, then go to the tribunal webpage itself. It looks like this. There are practice directions that are really clearly written, which won't be any surprise given how useful the manual is. And so go to something like practice direction 7 about the hearing process. That looks like this, and it steps you through each of the things that you might need to know. There's a couple of supplementary practice directions that complement these really meaty ones, like tribunal etiquette, things like switch your phones off, all that sort of thing. That really helps put people at ease to know that when they enter this possibly quite legalistic, quite tense environment, they're not worrying about a whole lot of other things of, who these people are and what should I do. This is all set out. So yeah, there's the web address there. The last thing that I do need to talk about is the role of expert witnesses, because they're really important in terms of how the tribunal works and how the tribunal weights up the various bits of evidence that are put before them, and how tribunal actually weighs different expert witnesses, because sometimes it might end up being the appellant's expert witness, their evidence weighed up against the other party's expert witness. So a really important thing to remember is that the expert witness that's appearing, for example the appellant, their overriding duty is to assist the tribunal. So the expert witness is assisting the tribunal as their first responsibility. They're not advocating for the parties. So the idea here is that the expert witness gives evidence as an expert, and when they're asked a question, they need to answer it in a full kind of and reasonable and responsible way in terms of providing information to the commissioners who are going to end up writing up a report and making a decision. And so they can't withhold evidence, they can't skew things because their overriding duty is to the tribunal. And as a professional, you're not doing yourself any favours if you do advocate for your client, and you'll start getting a bad reputation in terms of just not being a very good witness. So yeah, this is the kind of overriding thing to take away from any information about expert witness. Of course, in the popular press about planning, all sorts of people appear with an opinion. Not everybody's an expert. We might, read about what a well-known actress has to say, and there's a typo here, about a skyscraper proposal for Inner Hobart. She has no planning expertise. This is just part of the news cycle. So yeah, the cartoon here says, I know nothing about the subject, but I'm happy to give you my expert opinion. Expert opinion in terms of the tribunal and the formal decision-making process, it really matters. So why Essie Davis's opinion might actually matter in the court of public opinion, and people might be influenced to swing behind a proposal one way or another based on what a celebrity says. In the tribunal, the kind of strength of expertise, your history, your professionalism, it does matter, and decisions can be swayed based on somebody's track record and history, for example, around heritage architecture and heritage planning. So I hope this has been useful. We've talked about standing, we've talked about the first step of the appeals process in terms of that preliminary conference where the matters under dispute are made very clear, the power of alternative dispute resolution in all its different forms to avoid going to a formal hearing, mediation as a particularly well-used dispute resolution tool and the way that that works, and then the actual hearing themselves that I haven't talked about very much, but there's a lot of information on the website. And if you are interested, I do urge you to go to a hearing. They're advertised in the paper. You can turn up. It's a public fora. So yeah, and this can be really useful in terms of particularly preparing yourself, for example, for a career in planning, to go and do this before it's thrust on you as part of your professional responsibilities. So I hope that helps.